Hi, I'm Michelle. In this video, I want to cover durable powers of attorney. A durable power of attorney is the same as a regular power of attorney, except for one important feature. The important feature is that where a regular power of attorney ends on the description of whatever the task is that's listed in there, if it's a special power of attorney, or if it's a general power of attorney, that power of attorney ends if the person who gives the power of attorney no longer has legal capacity to act, which means they either by way of disease or circumstance cannot, they do not have the legal capacity to act in their own behalf or on behalf of anyone else. And so in that situation, under a regular power of attorney, where the person giving the power of attorney can no longer legally act, neither can the person who has the power of attorney. Most notably, that would be in a situation where they have dementia or they go into a coma and they're either physically not able to make decisions because of some problem in their brain, or they can't do anything because of some problem, for example, a coma. So dementia, Alzheimer's, anything where they have lost their legal capacity but they're still alive, that ordinary power of attorney is going to terminate. A durable power of attorney will continue on so long as the person is alive and beyond that infirmity. So if that is a situation that you want to address, then make sure you are aware of the laws in your state. It's best to have someone help you, but be aware that there are specific ways that these documents have to be drafted and certain language needs to be included. Because once you're acting with the power of attorney, you obviously want it to stick and you don't want it to be challenged later. Now, one other thing to keep in mind is that when you have a power of attorney, it is a durable power of attorney or a regular power of attorney. It's limited to what is specifically said in the document. So your powers to act on that other person's behalf and deal with their property in any which way is going to depend upon what's written in the document. The durable power of attorney does not mean that you're the guardian of that person or the conservator of that person. It simply is giving you the legal right to act with regard to usually their assets or themselves, and something it's set out in the document. A guardian is something completely different, and that's set out by the court system, and that's an official appointment where you become a fiduciary to look out for this person. So that's an important distinction. The other thing to keep in mind, if you have a durable power of attorney, while that power that you've been given goes after the person loses capacity, it stops when they stop. In other words, when they die, that power of attorney, the power under it ceases. So if you are in a situation where the person that you have the durable power of attorney for is reaching the end of life and you are trying to work to wrap up their property in a situation so that you can perhaps avoid probate, then you need to be aware that you can only act under that power of attorney as long as that person is alive. I hope that this information was helpful to you. If you have any questions or have any requests for anything along these lines for another video, please feel free to leave a comment. I'll see you next time. Thank you.